Turn to
Sorry.
talk.
I'm
It's not
sorry.
your turn to talk.
I'm sorry.
What you're about to watch is not a complicated legal argument or a nuanced constitutional debate. This is a courtroom collision between authority and chaos. From the very first seconds, the judge is not interested in excuses, explanations, or side stories. The issue here is simple. Show up for court, follow instructions, and respect the process, or face the consequences. Miss Riddle enters this courtroom already on thin ice. Missed appearances, prior warnings, a history of disruptive behavior. And instead of accountability, she arrives focused on spilled water, a phone, and a personal grievance that has absolutely nothing to do with why she's standing before a judge. This case becomes a real-time lesson in how not to behave in court. You'll see patience tested, credibility destroyed, and judicial authority asserted in unmistakable terms. The judge doesn't raise his voice to dominate, he raises it because control is slipping and order must be restored. As you watch this unfold, ask yourself, at what point does explanation turn into excuse and excuse turn into consequence? Because by the end of this hearing, Miss Riddle learns that court is not a negotiation.
I spilled water on my phone.
That's not priority right now. Come on. Come on. Come on. We're going in front of the judge again. Come with me. Come on.
Richie Lyons spilled water.
Ms.
when he
Riddle.
brought my car.
Ms. Riddle.
He brought my car
Ms.
to the
Riddle.
station last night.
You hear the judge talking to you right now?
Ms.
What's being on
Riddle.
that red X face of the
Ms.
TV,
Riddle.
please?
Get in front of the camera, stop yelling and carrying on, and behave yourself. Your
Richie
name.
This
Lyons.
moment sets the tone for everything that follows. The judge gives clear, direct instructions. Stop yelling, get in front of the camera, and answer basic questions. Instead, Miss Riddle repeatedly talks over the court, redirects the conversation to irrelevant complaints, and refuses to focus on the arraignment. Legally, this matters more than people realize. Courts operate on order. When a defendant cannot follow the simplest directive, stating their name, standing where instructed, it signals to the judge that stronger control may be necessary. What we're seeing here isn't just frustration, it's a breakdown of courtroom decorum. The warning issued is explicit. Continue this behavior and bond consequences will follow. That is not a threat, it's a procedural reality. Judges are empowered to detain defendants who obstruct proceedings. So pause here and consider, if you can't comply during an arraignment, how can the court trust you to comply outside the courtroom?
Your
Richie
name.
Lyons brought my car out front and
I
spilled
hear
water
it.
on my phone.
I don't want to hear it.
Last night. I need to
I
hear
don't
the
want
witness.
to hear it. Tell me your name. What's your name?
Teresa Riddle.
Your appearance.
He's my witness that he spilled water on my phone last night.
Ma'am,
My
Ma'am.
phone was
ma'am,
Oh,
I'm
so-
gonna, you know what I'm gonna do if you'd say another word? I'm gonna have them hold you overnight with no bond, and then we'll try tomorrow. And if you give me this guff again tomorrow, I'll just put you back in till the following Wednesday and we'll try again. So don't be carrying on with me. I'm in the middle of an exam. I'm gonna arraign you, but you're not gonna carry on like this. Do we understand one another? Yes or no?
yes.
All right.
Yes.
Now we're going to talk about the arraignment. Does she stand mute, waive phone rating?
Yes, sir.
Why wasn't she here?
Your Honor, my understanding is that some water spilled on her phone, and my interpretation was that prevented her from being able to call an Uber or whatnot to get here. But that is my best interpretation for my conversation. It's very.
Richie
This
Lyons
phone.
picked me up.
It wasn't your
I'm
turn
sorry.
to talk.
I'm
It was not
sorry.
your turn to talk.
I'm sorry.
Her phone got wet and it ruined her phone, and so she couldn't call. Is that,
Yes.
I'm just asking, is that true?
Correct.
Couldn't call, and she was unable to get a ride. She didn't have.
She lives on, and you still live on, ma'am?
No, I live at the
My
right now
client is unhoused.
temporarily.
She's unhoused. She's staying with a friend who happens to have a room at these. Now, she got a P.O. box she can give the court. Yeah.
Sergeant, how did you pick her up today? How did they pick her up?
Good afternoon, Judge. Detective Sergeant Mark Driscoll. After I was made aware that a warrant was going to be issued, I was able to realize Miss Riddle was in town on our flock camera system. One of our officers located her over at Walgreens made contact with her. They were made aware of the warrant, that she didn't appear this morning as she was scheduled to, and that's where we're back at it again today.
And she was at Walmart? Wait a minute.
Walgreens, Judge.
Walgreens in
our
Trenton?
city. Yes, sir. Can I add one thing to the phone idea
Sure.
real quick? And I know you're in the middle of the exam. So we have 8 from about 2 a.m. yesterday, last night, early this morning to 7 a.m. that Miss Riddle emailed council people and the mayor of Trenton to articulate an old case that she believes that we haven't investigated properly, make allegations that have been unfounded. And I'm not going to go too deep in the weeds because it doesn't necessarily pertain to this, but there's this repetitive behavior of her mass emailing and people that if she wanted to report a crime, she would, Miss Riddle, I'm not talking to you.
Ms. Riddle, Ms. Riddle, Ms. Riddle.
The judge is talking to you, ma'am. Don't talk to me, talk to the judge.
Ms. Riddle, look at me, ma'am, or I'm gonna cut this off and we'll arraign you tomorrow.
So my point, Judge, is I believe that her phone was operational. She was able to send 8 consecutive emails between 2 a.m. and 7 a.m. to the mayor of Trenton, to several city council members.
This is the turning point. Up until now, Miss Riddle's primary defense for missing court has been her phone allegedly not working due to water damage. But the moment law enforcement explains that she sent multiple emails to city officials and even the mayor, that excuse completely collapses. From a legal standpoint, credibility is everything. Once the court determines that an excuse is false or misleading, every other claim becomes suspect. The judge is no longer evaluating circumstances, he's evaluating honesty. And honesty is now in serious doubt. The repeated interruptions at this stage only worsen the situation. The judge is attempting to assess facts, and instead he's met with defiance, eye-rolling, and continued argument. Each interruption reinforces the perception that Miss Riddle does not respect authority or understand the seriousness of her position. Ask yourself, if your explanation unravels under basic scrutiny, what does that tell the court about future
council members? So to me, the excuse that her phone wasn't working, obviously working well enough, ma'am, I'm not talking to you again.
Stop it.
So that's just what I wanted to articulate, that we have this ongoing issue with her within the city, contacted people that she wouldn't report a crime to. Now her claim is that her phone was broken, Judge. That's where I'm at.
It was
Prepare forfeiture,
It got
ma'am.
by Richie Lyons, and I need to hear.
Ma'am, I'm going to really lose my patience here if I already have. I'm not going to ask you again. You don't want to show up on this case. You weren't here March 26th. You weren't here April 24th. You weren't here December 4th. I arraigned you yesterday and you didn't show up today. We're not putting the warrant in the lien, but I am forfeiting the bond. And the new bond's going to be $10,000, 10%. And if you post that and you don't show up, you know what I'm going to do next time? I will set $100,000 cash and you will be sitting in jail until I get ready to take care of this case. This is ridiculous. You don't get to do this. Ma'am?
I have evidence.
I'm not going to argue with you.
Here, the court moves from patience to enforcement. The judge carefully lists missed court dates, prior failures to appear, and repeated chances already given. This isn't sudden, it's cumulative. Bond forfeiture is not punishment, it's risk management. The court is responding to a pattern, not a single mistake. When the judge explains that future noncompliance could result in $100,000 cash bond in jail, that is the legal system drawing a hard boundary. The message is unmistakable. The courtroom is not optional, and compliance is not negotiable. What stands out most is the judge's clarity. There's no confusion about expectations. Show up, follow instructions, stop harassing officials. Failure to do so will escalate consequences. This moment asks a critical question. How many warnings does a court give before it has no choice but to act?
And that's it. We'll give you an early court date. Unfortunately, you just screwed yourself by not showing up today because Trenton isn't going to be back in front of me for 2 weeks. So I hope you can post $1,000. What, ma'am?
I need
Ma'am?
Richie Lyons here. He
I've
was the one who
ma'am,
spilled the water on my phone when he picked me up last night.
ma'am,
Do you believe Richie Lyons?
ma'am. I believe that you were
He's my only witness.
I believe if you were at Walgreens in Trenton, that you could have made it here for your court date. Period.
No, my phone
Ma'am,
died.
ma'am,
Read
ma'am.
the receipt. The receipt says
Ma'am,
that the phone was dead.
This hearing
when I
is
went to
over.
Taylor.
You don't understand. Same bond conditions as I outlined yesterday. Now you have to post 1,000. If you want to forfeit that, that's up to you. You must have a lot of money because you forfeited a
I'm
ton of
on
bonds
Social
on this.
Security disability, and I only
Ma'am.
get a pension from
Ma'am.
Customs and Immigration
Keep your mouth
for
down.
10 years. I
Ma'am,
served.
keep your mouth down. What, Sergeant?
Sorry to bother you, Judge. I know you got a hearing. Can we put in a stipulation for her not to contact? Because I don't want this to get to another harassment complaint. If she has complaints, criminal complaints, she's obviously welcome to come to the Trent Police. But contact with the mayor on complaints.
Well, I don't know. I can't. Hang on. I can't, ma'am. Will you please stop looking at him?
I can't
rolling.
believe what's coming out of his
I
mouth.
can't believe you roll your eyes and you're this disrespect. I just can't. Ms. Riddle,
I've been friends with Deb Devitt, with the
I
mayor.
don't care
I've been
who
friends
your
with them for
friends
10
are.
years.
I don't really care. I'm
I
friends with
did
Deb Devitt,
charity
but I could
work
care less.
with Deb
10,000,
and
ma'am,
all of those guys.
10%. I can't order that, detective. I mean, I can't order not that they're not witnesses to this crime, so I can't really order
Okay,
that. But you can't violate a law. So if you keep harassing them, they're going to charge you, and I'm going to forfeit your bond again.
I've only contacted them one time, Judge.
I don't want to hear it. I don't want to hear it. I don't want to hear it. No. What are we doing? The 29th. That's the best I can do for you. I hope you can post. January 29th will be your court date. At some point, you're going to learn to show up. January 29th at 9:45.
This exchange is pivotal. The judge directly challenges the defendant on his post-arrest contact with the victim and the conflicting statements about guilt. There's no legal ambiguity here. Contacting a victim in this context is inappropriate, whether direct or indirect. And the judge makes it clear. Experience with the system means the defendant should have known better. When the judge asks, "Did you or didn't you do this?" it strips away legal maneuvering. This is accountability at its most basic. The defendant's eventual admission removes any remaining doubt and sets the stage for sentencing. Judges take no pleasure in moments like this, but they are necessary. The court is assessing danger, risk, and the need for public protection. And in that assessment, manipulation and minimization weigh heavily against leniency. Ask yourself, at this point, has a defendant helped his case or sealed his fate?